A number of people have asked me why I took 2 years off from the practice of law, from defending consumers, which is my passion. And I promised to answer that question in a blog post, and it's a long story, but this is part of it. It goes back almost 10 years. I was one of the first attorneys in New Jersey to start representing people in foreclosure and to defend people in foreclosure and to try to prosecute claims against banks. It goes back to about 2008, 2009. And as time went by, the court system became more and more aggressively anti-consumer, and it was disheartening. But I kept fighting. I had a number of theories get shot down, including a consumer's right to make sure that they're properly notified of a default, that a consumer has a right to make a bank prove that they actually delivered certain documents, which the courts decided you don't have to do that. To require that banks, in order to foreclose, actually have to be able to enforce the note and mortgage. I know it sounds ridiculous, but for about 3 or 4 years in the middle of the crisis, the appellate division in New Jersey decided that a bank did not need to have the right to enforce the note, the debt underlying the mortgage claim, in order to foreclose. I fought that for 5 years. Eventually that issue was overturned, but a lot of people were devastated. That's not why I stopped. I stopped because, this is hard even to go back to, in New Jersey, there's something called the entire controversy doctrine, which, and I apologize for being wonky, but it is what it is. It's a legal concept that precludes parties from bringing actions that they could have brought in an existing claim. And it makes kind of sense on its own. You don't want people suing because they got punched in the face by a neighbor and then suing again after that's over because the neighbor also hit him in the leg. I mean, that's a ridiculous example, but that's sort of behind the idea behind the doctrine created by the New Jersey Supreme Court. That was applied to foreclosures, even though there's a specific statute which prohibits the courts from applying this to foreclosures. The reason why this was so difficult for me is because a foreclosure doesn't provide a jury trial. You get 3 months of discovery, which isn't enough time to demonstrate the bank's fraud, and there's no jury. But there's a statute on the books that says the entire controversy doctrine doesn't apply. So I found several different clients who were truly horrendously abused by the banks, terribly abused, horrible fact patterns. And I filed suit, and I had a 5 going on. I had 3 or 4 maybe ready to go. And the appellate division in New Jersey, right before I was get the jury trial on a case, on a separate case, decided that everything has to be brought to the foreclosure court. I took that issue to federal court, to the Third Circuit Court of Appeals. I took it to the appellate division. I took it to the New Jersey Supreme Court, where I had previously argued and won, and it went to no avail. This is wrong. It breaks the system. It allows banks who commit fraud to quickly file foreclosure complaints and thereby completely eliminate any possible chance of a jury. And that broke me. I believe in our system. I love our system. It's broken. It's terrible. It's the best system around. And I want a jury trial for my clients. I want a right to be able to prosecute banks for bad action. And the court system decided, essentially, whether they meant to or not, the appellate division in New Jersey decided that banks don't have to face juries when there's a foreclosure question. I did not want to become one of those lawyers who ran around pretending to promise modifications and pretending that they could provide the sun, the moon, and the stars when there was no judicial mechanism for doing so. So I wound my practice down, sold my building, essentially retired for 2 years until I could find a way to get banks to a jury even when a foreclosure complaint was filed. And I did. And that's why I'm back. And there's more to the story. Thank you.